Can a lawyer talk to their client during an Illinois divorce hearing or trial? When you're sitting in an Illinois divorce courtroom, you might assume you can freely whisper to your attorney at any moment during the proceedings. Under normal circumstances, attorney-client privilege fully protects every conversation between a client and their legal counsel throughout an Illinois divorce. However, once testimony begins, especially your own testimony, an Illinois judge has the authority to order that no further discussions occur until that testimony is completely finished. This restriction can span an entire multi-day trial, meaning the communication blackout holds across lunch breaks, evenings, and even from one day to the next. The reason behind this rule is straightforward. A witness conferring with counsel just before or during testimony raises serious concerns about whether that testimony is being shaped or manipulated. Illinois Supreme Court Rule 3.4b explicitly prohibits a lawyer from counseling or assisting any witness to testify falsely, and courts have long treated the procurement of false evidence as contempt of court. In criminal cases, the right to speak with your attorney at any point during trial is considered so fundamental that no showing of actual prejudice is even required to protect it. But Illinois courts have clearly established that divorce and other civil cases operate under a different and far less absolute standard when it comes to attorney-client communication during testimony. Illinois appellate courts have specifically held that the right to counsel in a civil case is quite divergent from the absolute right afforded to a criminal defendant. This issue has grown even more complex in the modern era of Zoom hearings, where an attorney could secretly text a witness during live testimony without anyone in the courtroom noticing. The same restriction against attorney-witness communication during testimony extends to depositions, where courts have held that once a deposition starts, counsel has no right to confer until it concludes. The most effective solution is thorough preparation beforehand, since a well-prepared attorney should never need to interrupt testimony to course-correct something that proper advance work would have already addressed. It is completely ethical and standard practice for an attorney to review direct examination questions with a client in advance, provided that every answer given under oath reflects the complete truth. Contact the law office of Russell the 500th. Knight at 773, 334, 6311, located at 1165 North Clark Street #700, Chicago, Illinois 60610, United States, to schedule your consultation with a prepared and ethical Illinois family law firm today.